Good afternoon, everybody. Glad to be presenting to all of you. And I know you just heard from my partner, Scott Simmons, and he spoke to you about pretrial motions and discovery strategies. So I guess I should introduce myself, tell you what I'm going to be speaking about. So my name is Susan Lawson. I am going to be speaking about jury selection and voir dire techniques and a little bit about myself. Okay. So my name's Susan Lawson. I've been practicing for well over 15 years. Most of my practice has been in the South Florida area, although I've practiced in multiple states. I am currently board certified in criminal trial law. And that's a little bit about me. I'm going to be talking to you about really a case can be won or lost depending on the jury you get on a case, right? So it's to me, this is the most important in all trial aspects. Your jury, who you get on your jury, is the most important. So we're going to be talking about first, developing effective jury selection, voir dire strategies, which voir dire means to speak the truth. Okay. Okay. So in talking about jury selection, what is key is preparation. So preparation is key, and knowing your case is so important. Okay. Case analysis. So as I was saying, preparation is key. So every case, whether it's a misdemeanor, DUI, or a murder case, right? I've tried all kinds of probably any type of criminal case I've tried in my career. And every case should be handled and prepared similarly, but in the same sense, it's important to know your case, because the way you're going to pick your jury is going to be there are a lot of common concepts, but it's also going to be very case specific. So before your jury selection begins, it's critical to thoroughly analyze your case. Okay. So meaning go through your discovery, know your evidence, know your witnesses, know your theme and your defense of your case, and also anticipate the other side, what the prosecution or the state attorney is going to be likely to present. And identifying the themes of the case can help determine what kind of jurors might be most receptive to your arguments, okay? Because, there are some jurors who would be great for one kind of case who would not be good for another type of case based on their own personal experiences they come into the courtroom with, right? So some jurors might be great for one case, but not all cases. So it's really, really important to start thinking very early on, knowing your case, doing an analysis of your case, and really thinking about what type of juror do I want on this particular case. Okay. So you want to jury research. Doing your research as far as prospective jurors is very important. So depending on what kind of case it is, and high profile cases or cases with significant resources, sometimes we'll hire jury consultants to research these potential jurors ahead of time. The goal in jury selection and getting that right panel to win your case is to find out as much information about the prospective panel or these potential jurors. So this could include examining social media profiles. So a lot of times, and we're going to go through, if we get the prospective panel ahead of time, right, we could do research on their Instagram, Facebook, whatever social media platform they have. Sometimes, most time where we get the prospective panel as they're right before they're walking in. So that's why it's great to have a trial partner. And with the trial partner, like if I'm sitting on a case with somebody else, I am actively looking up and doing research into these people's social media profiles, because you can learn a lot about an individual based on things they post on social media. So you also want to, know previous jury service. A lot of times, jurors who have previously served before, right, those end up to be your forepersons on a jury. So it's good to know if someone has previous jury service, because they're normally your foreperson. They normally know, based on their prior service, how things go. So that's always good information to know. Or public records to identify biases or preconceptions that might affect their case. So jury research, such as surveys, focus groups, and mock trials. So we always think it's really, really important after you do your case analysis and before you're going to court to pick your jury, right? I will try to talk to as many people and run my case by as many people as possible to get their, thoughts and opinions. But ultimately, what I'm trying to find out is who would be a good juror on this case. So, talk to your family members, talk to your coworkers, talk to your, parents at sports games. Hey, what do you think of that? The more people's inputs and opinions you can get ahead of time and doing your research is really, really helpful to know, again, what juror are you looking for in this particular case? So we have a case right now as far as focus groups. What is that? We have one right now that's probably going to be going to trial at the end of the summer, early fall. And we have hired somebody who is bringing in people in the community and doing a focus group. It's kind of like a mock trial, right? We're going to be presenting our case to random people in the community, just like you would get if you were, it's like a practice jury selection. And we're going to do things to practice so we know, again, who are we looking for in that particular case. So really excited to get that focus group started. Now, key questions to ask when preparing for your jury selection. Okay. So will the judge allow a jury questionnaire? Okay. So some judges will, some judges won't. It depends on where you're practicing. But if not, consider filing a motion to request the use of a questionnaire. And then prior to doing so, find out if the questionnaires length is limited and if the judge prefers a particular format. No matter where you're practicing, you need to know your judge and how they handle jury selection. You should also develop a strategy for negotiating the form and content with the other side, so the judge understands that the process, it's not going to impose a burden on their time. It's actually going to make the process more effective. You should also know which voir dire questions, if any, will be asked by the judge. So down here in South Florida and Broward County, most judges have a set of questions, they're going to ask, which includes state your name, where you live, how long you've lived here, have you ever served on a jury before? Have you ever been a victim of a crime? So you need to know if in preparing which questions, if any, the judge will ask. Another good thing you want to know ahead of time in preparing is, does the judge allow the parties to submit questions for voir dire? If the answer is yes, does the judge typically ask the questions in the order submitted? Do they ask follow-up questions? Stuff like that's good to know. So again, I've practiced in multiple jurisdictions, and when I moved from Florida for a little bit to Maryland, I was very surprised to learn that the attorneys are limited to ask very few number of questions. But that's something you need to know. Our attorneys are allowed to ask specific questions. Are there any topics that you can't ask about? Okay, so that's important to know. Whether asked by attorneys or the judge, will questions need to be submitted prior to voir dire? If questions must be submitted, right, in advance, it's important to know how soon in advance. It's always a good idea. We always look at judges, go to their policies and procedures and see the particular judge you're going to be trying the case in front of. What is their policy? What is their procedure? How much time, if any, will the judge allot to themselves and each side? So does the judge have time constraints, right? There's case law in Florida that the judge can't, limit the amount of time you need, right? So that's important. Again, we're going to get into case law and knowing your case law in a little bit, but it's important to know, are you potentially going to be restricted with how long you can speak to the prospective panel? Will the judge provide a seating chart? Most judges here do, right? And they have the jurors numbered and they have the jurors sitting in their particular seats. And we know the seating chart corresponds to where the jurors are sitting. But it's important because sometimes we have to make our own seating charts. So that's something to know. That's important to know ahead of time. Will the judge or clerk simply put the next consecutive prospective juror, or will the prospective juror be randomly selected? So how's that going to work? What is the judge's recent track record regarding hardship strikes for long, complex trials? So it's good to know if the judge will pre-screen jurors for a hardship, and how is that going to work? So that's something good to know ahead of time before going to pick your panel. And what are the rules and what does the judge normally do for the exercise of peremptory challenges? And we're going to get into peremptory challenges, but that's something good to know. How much time will the judge allow the parties to make their peremptory strikes? How many jurors will the judge sit in the jury box? Will the judge allow a consultant to sit at the table? Those are all really, really important things to know and to prepare for ahead of picking your jury. Okay, so preparation. Again, what else do you need to prepare for picking your jury? So you want to prepare effective questions. So in picking your jury, in voir dire, we want to ask potential juries a series of questions to uncover their biases, right? Because what are we looking for? A fair and impartial jury on whatever particular case you're trying. So open-ended questions are particularly useful as they encourage jurors to speak freely about their thoughts and experiences. For example, asking, how do you feel about the criminal justice system, can provide insights into a juror's beliefs and attitudes, right? I always say, ladies and gentlemen of the jury, we don't expect you to leave, you all come in here with life experiences that we don't expect you to leave at the door, right? But we need to know about those life experiences. And I try to encourage them to talk, ask open-ended questions. And I always say, the more you talk, the quicker I could get through this. And, because this is the only opportunity that we get to speak to the panel and ask questions to the panel. And something that's really good too is when you're speaking to these jurors and juror A says something, gives you a response. Another way to get another juror talking is to say, juror B, what do you think of what juror A just said? Do you agree? Do you disagree? Share your thoughts, right? We want to get them talking because, as we know, what is not most people's number one fear? Public speaking, right? And they just come in a courtroom with all their new best friends. So most of them are, we have some who are going to try to talk a lot, but there's a lot of other ones who are going to be more reserved, and you got to get them talking, right? So it's important to also prepare case-specific questions. Tailoring questions to the specifics of the case can help identify jurors who might have preconception or biases, right? So we do a lot of DUI cases here at the Rossen law firm. In a DUI case, for example, you can ask, have you or anyone close to you been affected by, a drunk driver? A lot of people who have a DUI it's very common, obviously, and a DUI may not be the right case for them. So we need to know about their personal beliefs, their life experiences that could potentially affect their ability to be fair and impartial in this particular case. Hypothetical situations. So again, it works. You got to have your own style. You got to, be who you are. Don't change who you are. So hypotheticals sometimes work better for others. They don't work great for me, but I've seen a lot of Certain ones work good for me, but I've seen a lot of people really, hypotheticals have really worked for them. So if it works for you, great. That because presenting hypothetical scenarios related to the case can also be an effective way to gauge a juror's potential reaction to the evidence. For instance, if you were presented with this type of evidence, how would you evaluate its credibility? Can reveal a lot about a juror's thought process. Developing effective questions. As we're talking about, as we keep speaking about, voir dire questions are used to uncover potential jurors' relative biases. But it's really important to tailor your questions to elicit responses that connect to the themes of your case. Now, in criminal defense, right, there's certain topics you cover, right? No matter what case it is, you're going to cover the three major legal topics of presumption of innocence, burden of proof, and reasonable doubt, right? But then there's also those added questions based on the theme of your case that you want to make sure you incorporate in your preparation when you're preparing your questions. The value of preparation and flexibility. Again, be thoroughly prepared, but also flexible in adapting your approach based on how jurors respond during voir dire. Okay. So you want to prepare, you want to have your questions, but something that's just as important when the prospective members of the panel are talking, listen to their responses. And again, build off their responses. Because the goal is to create a jury that will fairly evaluate the case and ultimately reach a just verdict. Like, we want to, again, know as much as we can about these individuals and select the right ones for our particular case. But you have to listen. You have to go up there confident, because that's really going to help you get the right jurors for your case. So creating a juror profile. So you want to define your ideal juror. Based on your case strategy, create a profile of the type of juror who would be most sympathetic or neutral towards your client. Consider factors such as age, education, occupation, life experience, and personal values, right? For example, if you're trying a battery on a law enforcement officer, someone in law enforcement might not be the best one on your panel. A lot of times in criminal defense, law enforcement officers aren't the best jurors to want on your panel. However, there is certain situations where they happen cases. That's why it's so important to know what type of juror. For example, if you're trying, a case involving where there's going to be medical records introduced, you may or may not want someone in the medical field who, has that knowledge. So that's why it's so important to try to figure out ahead of time who would be best for your client based on the particular case, right? And you want to look for jurors who can relate to the defendant. Also, the jurors are coming in, right? When they're all walking in, they're staring at the defense table. And I always say, you're looking at my client and you're thinking, what did that person do? And I always try to change their mindset. And it's not what this person did. It's, again, what can the state prove? Because it's their burden. But the jurors are watching you. They're watching your client. So, it's important to interact naturally with your client. I always tell my client, be natural, make eye contact, right? Because you want them to like you and your client and relate to you. So if your client comes from a particular background, a particular race, status, or profession, you may want to focus on finding jurors who can understand or relate to the defendant's experience, which could foster empathy, okay? They're instructed that you can't decide on a verdict because you like or dislike or feel sorry for a person, but it's just natural that you want somebody, prospective jurors, you want someone on your panel who can relate to your client. We kind of spoke about this already, but again, we want to conduct internet searches on potential jurors, whether that's depending on when you get your list, whether that's prior to or during jury selection. And this is saying, like we spoke about before, there is often limited amount of time to conduct searches themselves. The jury list may not be available more than a few days before trial. In some cases, is only available, as we spoke about, when voir dire begins. Again, there is often valuable information to be gained by such sources. So, okay, preparation is key, right? So spend the time looking, knowing your case, doing the research, figuring out what type of jurors you want, figuring out what would be the best questions to ask, all before you're getting in there and the panel walks in. Building rapport with potential jurors, so important, okay? That's what we're going to get into next. So you have a short period of time, and you want the jurors to tell you or show you if there is anything that, in our case, will prevent them from voting not guilty in your case. So, as we spoke about, get them talking. Whatever it takes to get them talking, get them talking. I make it a common practice. In my cases, I will make sure I speak to every single one of the prospective jurors. Okay. And the quiet ones, I will try to do everything I can and prepare and try to get them talking. You need to get them talking. Don't be satisfied with silence, because there's nothing worse than if you get a juror on your panel and you do not know anything about them. That is scary, and we don't want that to happen. Okay, so how do you build credibility and rapport with the jurors? So making eye contact, right? I just mentioned that I tell my client, be natural. Don't overly stare at them, but make eye contact, right? Smile when appropriate. Be yourself. So it's great to have a trial partner, because when say I'm picking the panel and engaging with the jurors, right? I don't want to be up there, listening, asking questions, and writing down and taking notes. That's what you need a trial partner for. So have someone else write the notes. Also, call them by their names. I'm not the best at pronouncing names, so I'll always apologize in advance. I'm sorry if I mispronounce your name, but it's important to preserve the record too, to identify each juror you're talking to. But I also feel it's to personalize them. It's very important to call them by their names and generally be interested in their responses. That's the listening we were talking about. And, I get up there, and most importantly, it says, thank your jurors when they're done sharing. Sometimes it's really personal stuff that's hard to share in front of their new best friends. Sometimes they'll say, ask to speak in private because they don't feel comfortable talking about it. But if they're sharing and being brutally honest to share a bias against your case with you and to tell you about some life experiences that's not comfortable to talk about, not only thanking them in the beginning and telling them how important their job is and for being there, but when they share that information with you, thank them, right? Also, again, listen. Don't cut them off. Don't speed to the next question while they're still talking, and do not shy away from a bad response. Believe me, you want to hear bad responses. And if you aren't hearing any bad responses, more likely than not, you don't have an amazing panel. You're not asking the right questions. And the last thing you want to do is have a biased juror make it on your panel because you didn't make them feel comfortable enough to be able to let you know about that bias, right? When someone expresses a bias, consider it a wonderful opportunity to ask any juror if they feel the same way. And again, we spoke a little while ago, that's how you get jurors talking. Miss Smith just indicated that she does not believe someone should ever get behind the wheel of a car if they've had anything to drink, even though it's not illegal to drink and drive, you tell them, and it's just if their normal faculties are impaired. Some people will still believe, right, that no one should have a drink and get behind the wheel. So if Miss Smith says that, then you can say to Mr. Perez, you heard what Miss Smith says. Do you feel like that? Tell me how you feel about that. Do you agree? Do you disagree? This is how you get them talking. So it's a wonderful way when someone says something to ask other jurors if they feel the same way. Personalizing your approach to jury selection. Again, I could talk all day. I love picking jurors. I love jury selection. I think it's great. It's so, and really just, it's so important. But no matter, I'm just giving you tips, but you still have to make it your own. Personalize it. Be yourself. Always be yourself. It never works to try to be someone you are not. So when I was a junior lawyer, and I started my career out as a public defender, one of the things I would do is I would try to watch as many different defense attorneys pick a jury, right? And you pick up tips by the more you watch, the more you learn, and you'd pick up tips. But you cannot, it's not like reading a script. The jury will pick up if you're trying to be someone you're not, if you're presenting a phony presentation. And that is one way you, along with your client, will lose all credibility with that panel. And we do not want that to happen. So be yourself. Do not try to be somebody you are not. Okay. So again, you can write down in your preparation key things you're going to talk about. There's legal topics, again, I always cover. But again, how I was talking about how hypotheticals work for some people, you may think, oh, I just watched this defense attorney get up there. I love that hypothetical. Practice it, try it, because it may work for them and not for you. So you want to figure out what works for you. So how do we identify and address juror biases? Okay, because that's what we need to do. That's the goal. That's the point of jury selection. So what are we looking for in identifying and addressing these biases? Implicit biases. So jurors may not be consciously aware of their biases, but clues can give them away, such as body language, hesitation, or contradictory statements during voir dire. So when I'm picking a jury, right, I always tell, if I'm with my trial partner too, when the charge is being read, I want to see everyone's reaction when they hear that information or indictment, when that charge is being read, because you can tell a lot. They're not saying anything, but you can tell a lot by just watching them, right? Prejudice opinions, what to look for. Look for them. Strongly held beliefs or opinions about certain groups, racial, gender, or economic biases can often be uncovered during voir dire. Exposure to pretrial publicity. Jurors who have been exposed to media coverage or social media regarding the case may have preformed opinions that need to be addressed. It's very important. If your case was in the news and the media, if there was, you're trying a case and there was a similar case in the news and the media, it's important to know that, because that can uncover biases. Okay. So you're trying to get that information. Personal experiences. Jurors who've had personal experiences or relationships with parties involved in the case may struggle with impartiality. Well, in at least where we practice, it's always we'll read the list of potential witnesses. Everyone in the courtroom will be identified. And, the judge will ask, does anyone recognize anyone in this court, any of the courtroom personnel, any of the lawyers, any of the people on the witnesses list? Because obviously that would create a bias. Reading nonverbal cues. So this is like what I was just speaking with in body language when the information or indictment is read. So jurors' nonverbal communication, such as eye contact, body posture, and facial expressions, can provide clues about their attitudes and comfort levels. A potential juror who avoids eye contact or appears closed off may have reservations or biases that they're not expressing verbally. You can tell a lot about you can read a lot about a person through their body language. In addition to body language, I always try to pay attention to, what they're wearing, what kind of purse they have, what kind of shoes are they wearing. Things like that, believe it or not, you can learn about a person, right? And that's what we want to learn as much as we can about these potential jurors. Group dynamics. Observing how potential jurors interact with each other during breaks or before the selection process can also offer insights. So, very important. So it's interesting because if we get breaks or lunch breaks, you will see certain jurors, eating with each other, sitting with each other, talking. So you can learn a lot about, who's connecting with who on the panel. Group leaders who others naturally look to for guidance can influence the dynamics of deliberation. So verbal and nonverbal, very important to look out for. Okay, so something that is very, very, very important. So you have a lot to worry about. You're preparing, you're trying to gather information, you're trying to get these people talking, you've got to listen, you got to look for these nonverbal cues, but you also have to make a strong record during jury selection because it's critical for preserving your client's rights and ensuring the appeal process is as strong as possible. So how do we do that? So listening not only to the prospective jurors, but listening to the state attorney, the opposing counsel in your case, is so important. So if the opposing counsel or the judge asks improper or prejudicial questions, raise an objection immediately. And I gave an example that we just recently had in one of our trials. Depending on what kind of case we have, we sometimes have very experienced prosecutors, sometimes newer ones that haven't been out of law school that long. But in a recent trial we had the state attorney, when they began their questioning or during their questioning, they brought up the defendant's right to remain silent. And case law is clear as far as that in Florida, that the only person who could bring up the topic of a defendant's right to remain silent is the defense. So we objected right away. And then how do you deal with when the opposing counsel, when they say something inappropriate, how do you deal with that, right? So you can consider asking for what's called a curative instruction. And as far as curative instructions, I always keep in my notebook a curative instruction that I'll give to the judge and suggest that they read if that's what I'm trying to do to remedy the situation. Because a weak curative instruction does not usually make the jury ignore the improper comment. So you want to ask for one like such as this one. Ladies and gentlemen, I have stricken the last question asked by the prosecuting attorney. It was clearly improper, and you are not to consider it in any way, shape, or form, or draw any inference whatsoever from the fact that the question was asked. It was improper, and the court has stricken it. Now I'm going to ask each one of you individually, can you promise me you strike this or any interference from the question from your mind and not consider that question in any way, shape, or form in arriving at your verdict in this case? Can all of you say yes? So it's very important to just, a curative instruction shouldn't be disregarded, right? It should be proper. It should be not only that, it should be saying that the state attorney's comment was improper and then asking each prospective member of the panel, can they disregard it? So another remedy is to move to strike the panel, right? So if you get that opportunity, no matter how good of a panel you have, a lot of times that is the right thing and that you should move to strike the panel. A judge may not always grant your request to strike the panel, but if they don't, then again, what's the goal? We're preserving the record in the event that we lose and we need to appeal, right? So a lot of appeals are won based on things that happen in jury selection. Case law related to jury selection, right? So something that's very important is knowing your case law. And case law varies according to what jurisdiction you're practicing in. So it's important to know your particular case law for wherever you're doing the jury selection. But a lot of it, I cite to, some helpful cases, and these are going to be from where our primary practice is, which is in the 4th District in South Florida. But again, know your case law for where you practice. And a lot of it is very similar depending on where you are practicing. So in Florida, section 913.0310, and the test is whether the juror can set aside his or her biases or prejudice and render a verdict based only on the evidence presented and the instructions given by the court. A juror may be excused, and we're talking about a cause challenge, if any reasonable doubt exists as to whether the juror possesses an impartial state of mind, okay? So, and these are just cases related to the 4th DCA, so if you practice here, it's helpful. If not, again, I know there's similar case law. It's all the same principles. Not able to discuss a topic, to preserve limitations on questions posed to the veneer, identify the area of inquiry you wish to address, and state the manner is relevant to juror biases, okay? A lot of times, so if they're not letting you discuss a topic when you're trying to talk to the panel, you need to object and lay a record. You have a right to question the panel on your theory of defense. And if you are being prevented, that's critical to maintain your appellate right and object, okay? Because the single thing that in this case that the defense counsel needed to know was whether the prospective panel could fairly and impartially consider their defense, and they were presented to doing so, and that came back because you have a right to question them on your theory of defense. Okay. Convicted felon, trial court abuses discretion in limiting the scope of voir dire. A meaningful voir dire would have included questioning the jurors as to whether they would be biased against the defendant because he was a convicted felon. That's another, and I have all the case. If we need the slides, you can get them. I'm not going to go over all the case citations just to save some time, but I'm just going to go over the principles. A juror said who defends criminal conviction would be in the back of his mind should have been stricken for cause because the juror couldn't be fair or impartial. Improper comments by the trial judge. This case was reversed on a judge's comment in voir dire after 3 prospective jurors commented that they could not convict without physical evidence. Judge gave a hypothetical which suggested that if eyewitnesses to a crime were identified, 100% defendant should not go free, right? That was improper. You have to keep your judge in check too. Your judge must stay neutral. No tips. I've had to deal with this a lot in county or misdemeanor court with the new lawyers. The judges are trying to help them, but they can't do that. They have to stay neutral. Yeah, in this particular case, the Florida law expressly prohibits a trial judge from stepping away from the appearance of neutrality to become an advocate for either party. And in this other case I cited, the trial judge serves as the neutral arbitrator in the proceedings and must not enter the fray by giving tips to either side. Okay, but we got to object when that happens. Hypotheticals are okay. We talked about hypotheticals already, but it's well settled that in the scope of voir dire properly includes being able to ask questions about and reference to the legal doctrine, and even if stated in the form of hypothetical questions. So if you want to use a hypothetical and your judge is not allowing you to, again, object, preserve your record. It's important to have these cases handy when you're picking a panel so you can cite to them. Time limit. Mentioned this earlier. As far as time limit, although in this case the court was concerned about the time limitations imposed by the trial court, the appellate did not preserve the issue for appeal because he affirmatively accepted the juror without renewing his prior objection. So that's something we're going to talk about, but prior to accepting a panel, you don't accept. You have to renew your prior objection. And this one, Joyner v. State, talks about an acceptance of a jury panel, waived the objection, okay, because in this particular case, the Neil Sloppy, meaning in Florida, that the record reflects that the juror is part of a protected class, and they're dealing with a race-neutral reason, and they were not allowed. There was an issue in the case, but the attorney failed to renew the objections before the jury were sworn or to accept the jury. So they waived their objection. So very important to do. And that, here we go. That's what we're getting into. The importance of not accepting a panel prematurely. Okay. And I didn't realize, I apologize, that the wording on these slides are kind of small. But basically, to summarize, there's two types of challenges, right? You're not limited in the number of for cause challenges you make. And essentially, a for cause challenge is something the juror said. They didn't have the qualifications required by law. They're of an unsound mind. They have a conscious belief that would preclude them from being fair. The juror served on the grand jury that found the indictment, so they have a preconceived bias. The juror is an adverse party. These are all different ways a juror can be stricken for cause, okay? And we have the slide to go over this, but basically, it's a for cause challenge. You need to raise that, right? So there's something, they said that they would need to hear from the defendant, right? Then you raise a for cause challenge. They say that they believe they would lead a law enforcement officer over a lay witness. Again, you ask for cause challenge. So very important to ask for those challenges and preserve your record as it relates to them. Now, peremptory challenges are, essentially that you can raise them. You can ask for any reason for a peremptory challenge. So depending on what kind of case you're trying, if it's a felony punishable, because we still have the as far as if you have the death penalty or you're facing the charges punishable by life, you get 10. So you get 10 peremptory challenges each side. All other felonies in Florida, you get 6 if the charge is a felony, but it's not punishable by death or life. Misdemeanors, you get 3 if the offense is charged as a misdemeanor. And then if 1 or 2 alternate jurors are called, each party is entitled to 1 peremptory challenge in addition to those otherwise allowed by law for each alternate juror called. And then I cited it's in the small print at the bottom, but the State v. Neal, which held that peremptory challenges may not be used to exclude jurors based on their race, ethnicity, or gender. So you have to have a reason. You have to have a reason, because sometimes that will be brought up, that someone's trying to exclude someone based on their race, ethnicity, or gender. So, you just have to have a reason to use a peremptory challenge. Okay. But let's see. And now we're going to go to what we're talking about. Very, very important. And people forget this all the time. So you must not accept the jury, right? You must renew all objections. Okay. This is so important. And I cited case law as far as jury misconduct. And that says, although counsel did not formally accept the jury panel, counsel failed to renew objection or move to strike the panel before it was sworn, and thus failed to preserve their appellate claim. So you have to not accept the juror and renew all your objections. Here's another case, denial of a cause challenge. The attorney did not preserve for appeal the issue of whether the judge erred in denying a cause challenge. They didn't renew objections to denial of requests for additional peremptory challenges at the conclusion of the jury selection before the jury was sworn. So super, super important. Prosecutorial misconduct cases. Counsel waived the claim that the prosecutor made improper remarks during jury selection by failing again to renew their objection and motion for mistrial before the jury was sworn. Okay, so preserving your record is so important. So before I get into any questions that you all may have, I just wanted to go through what we've covered today, because again, I could talk about this for a long time. So again, after you're preparing, when you're preparing your questions, right, when you get up there, you want to introduce yourself, your co-counsel, and your client, right? You want to let the jury know these questions are not meant to embarrass you, right? We want to make sure we have the appropriate juror for this particular case. And so you need to know, you heard the nature of this crime. You heard that this case is an aggravated battery with a deadly weapon, right? Just hearing the nature, just hearing that charge itself, you need to know, is there anything that would prevent you from being fair and impartial, right? Some people would rather sit on a murder case than a DUI case, for example, okay? You want to know about their life experiences, right? You want to know about the experiences of the family and friends. You want to know about their connections with law enforcement, if they've ever been a victim of a crime, okay? And then you want to stress, right, certain things and explain to them, like I mentioned earlier, when they hear the information, that it just tells you what you're charged with. It's not evidence, right? And I always say, has anyone ever gotten a traffic ticket? And you'll have a bunch of people raise their hand. And you'll say, Miss Smith, when you got that traffic ticket, what did you do with it? Did you take a plea? Did you fight it? And if they say they took a plea, Charlene, why did you take a plea? Because I was guilty. Okay. All right. Mr. Perez, what did you do? No, I fought my traffic ticket. And why did you do that? Because you were not guilty, right? And then I'll go through again. I really, really stress the three legal topics of presumption of innocence, because it's so important that the jury understands that your client is presumed innocent, and that it's the state's entire burden and what the burden is beyond a reasonable doubt. So I'll go through hypotheticals in those different legal topics, okay? And I will, again, try to speak to every single juror and make sure they understand those topics. So we're educating and we're gathering as much information as we need. So, okay, I see some questions so someone asks, when should attorneys strategically withhold a peremptory challenge to force the prosecution into using one of their own? So that's really good question. And it's important. This goes back to knowing how your judge handles these situations. So in Florida, you're allowed back strikes. So a lot of times we do just that. So we will accept the panel to see if we could force, it's like a chess game, right? So we will accept the panel and see if we can force the state to use one of their peremptory strikes. And then if they don't, then we'll, a lot of times we want our client to be very involved in the selection. And this is all done outside the presence of the prospective panel. And we'll say to our client, okay, we have Ms. Smith and Mr. Perez. Which one? You get to pick one. Which one do you dislike more? And I always stress to the client, focus on the people you would not want on your panel. Because the reality is the ones you really want on your panel, the state's going to get rid of them. So that's just another good tip too. So another question. What are the best ways to track and analyze the opposing party's jury selection strategy to anticipate their peremptory strike? So normally, again, that goes back to trying to know the opposing party or the state attorney's theory, what they're going at. So as well as preparing for the individuals you would want on your panel, you should think about the type of individuals the opposing party is going to want on their panel, okay? And then, or not want. So if they don't want them, then you're going to prepare that they're going to probably want to use one of their peremptory strikes on that individual. Next question, how does a poorly selected jury panel impact trial strategy? And how should attorneys adjust if they end up with a less favorable jury? So hopefully you're not in this situation, but I'm sure I know it happens. So, right. So if you, I thought I was saying if you end up, I was going to say, if you end up with a bad jurors who you don't know, then you really didn't do a great job in your jury selection. But yeah, sorry. We get this all the time where, especially in the afternoons, we get the leftover jurors. So if we get a jury panel that's not good, then what do we try to do, right? We try to get as many people off of that panel for cause, okay? And we try to use all our strikes, and we try to bust the panel. So we try to not get a jury panel from those people so we can start over with a better panel. Next question. What are the most common mistakes attorneys make in finalizing a jury, and how can they be avoided? So, ultimately, it's your client's life and your client has to make the final decision, but, you have to guide your client because you're the experts and not them. So a lot of times it's, really sitting because the judge is going to ask, like, is this your panel? Is this who you wanted on your panel? Because it is ultimately their decision, but you got to educate your client, and it's really important to build that rapport. We talked about rapport with the jurors. You also need to have that rapport with your client, so they can trust you in picking the right people. And it's also extremely helpful. Always recommend, we talked about having a jury consultant if possible, but having that trial partner, that extra set of eyes and ears who can help you, and you can sit down and say, hey, what do you think of this person? Did you hear them say this? How do you think it could influence how they're going to see this case? So really, really, and they're the ones hopefully taking notes for you as we discuss. So it's very important to try to make sure if you can get that done. So what steps should an attorney take if the court refuses to grant additional peremptory challenges after denying a challenge for cause? So I don't think I mentioned this, but if you use all your peremptories, you can ask for more. But if you're refused, again, this comes down to a renewing your objections and not accepting the panel. So next question. In what circumstances should attorneys move to strike the entire panel rather than focus on individual jurors? So if you think that, again, you got that crappy panel, and you're not going to be able to get, if it's a felony, let's say six jurors on that panel, then your goal may be to try to get as many people off to, not get that panel. But you also have to prepare. You got to pick. Sometimes you're left with picking the best of whatever that panel is. Okay. Next question. How can defense counsel leverage for dire questions to maximize the effectiveness of their peremptory challenges? Okay. So something that's important, that was a good question. And that brings me to, if the state attorney gets up and speaks before you, right? And someone said something that's going to cause them to be able to get a for cause challenge. Okay. They say something that clearly indicates they're ability to not be fair and impartial. If you like them and you want to keep them, when you get up there, you can try to rehabilitate them, and you have to be very, again, that's listening and asking the right questions. Sometimes you can't rehabilitate them, but a lot of times you can, right? For example, if someone says up there that, I'm going to try to think of an example. So someone gets up there and says they would not, they would believe law enforcement. Oh, actually, let's think of a better example. So if someone gets up there and if you hear the state attorney, they're trying to move a person for cause because that person is saying they would need more evidence than one witness. Okay. So that's a problem if someone says they would need more than one witness. Okay. You can get up there and say, Mr. Smith, Miss Smith, I heard you say to the state that you would need more than one witness. Isn't it really you would want more, but you would still be able to follow the law if the judge instructs you that one witness is enough and you believe that witness is credible beyond a reasonable doubt. So there's different ways to rehabilitate witnesses, and that's really important, and that's a strategy and a learned art and technique that a lot of times state attorneys and opposing counsel are like, yes, I got that person, and then for cause, and then you get up there and you rehabilitate them. So that's great. I'm glad we got to talk about that because I did forget to speak about that. Let's see. What are the risks and benefits of moving for a mistrial based on a tainted jury panel, and what is most strategically appropriate? This really comes with experience. So I have always found, generally, no matter how good your panel is, if you get the opportunity to ask for a mistrial, you should, because again, judges aren't always going to grant it. And if they don't, that's a great appellate issue. I learned early in my career, I always remember kicking myself where my client was like, no, I like this panel, don't move for the mistrial. And I didn't, and I should have. So normally I always say that if you get the opportunity to ask for a mistrial, you probably should. Okay. If anyone has anything else they would like to discuss further after today's presentation, I would love to chat with you. If you have an upcoming trial and you want to bounce some ideas off each other, feel free to reach out to me. Again, my name is Susan Lawson. I'd love to hear from all of you guys or anyone and help any way I can. This is the you can scan and get my information. But again, we all are with the Rossen Law Firm. Our phone number is 754-206-6200. My email also is my first name, Susan, @rossenlawfirm.com. Thank you, everyone, so much for your time and attention. And I hope everyone has a wonderful rest of their day.